Wayne LaPierre is going to get $17 million for quitting, and one NRA executive just made a deal with the Attorney General in New York, and he got off easy. And I want to keep you involved. I want to keep you up to date. I want to keep you informed on this as it unravels, because this is an evolving story. You want to stay in the know, like the video, share this video, subscribe down below, and hit the bell icon so that you're notified of when I put out new content or go live. Yesterday, I broke the news that Wayne LaPierre, the Executive Vice President and Chief Executive Officer of the National Rifle Association, announced that he was resigning. Resigning just days before the start of a civil trial over allegations that he treated himself to millions of dollars in private jets, yacht trips, African safaris, very, very expensive suits, and other extravagant perks, all at the NRA and their members, their dues-paying members' expense. Wayne said this: "With pride in all that we have accomplished, I am announcing my resignation from the NRA. I've been a card-carrying member of this organization for most of my adult life, and I will never stop supporting the NRA and its fight to defend Second Amendment freedom. My passion for our cause burns as deeply as ever." Comment down below what you think about that little statement. Well, as a parting gift, the man who has led the NRA's day-to-day operations since 1991 will receive $17 million. $17 million. Yeah. The trial is scheduled to start on Monday in New York, where Attorney General Letitia James is suing Wayne LaPierre, the NRA, and 3 other executives. Retired NRA Finance Chief Wilson Phillips, not the band, NRA General Counsel John Fraser, and Wayne LaPierre's ex-Chief of Staff, Joshua Powell. Now, James alleges that they cost the organization tens of millions of dollars from questionable expenditures, including lucrative consulting contracts for ex-employees and gifts for friends and vendors. Three executives. Well, make that 2 other executives, because one of those executives, Joshua Powell, yesterday made a deal with Attorney General James from New York, and I think he got off easy, but I'm going to let you be the judge. Before I get into that, I want to thank the sponsor of the video, and that is the Sonoran Desert Institute. I know a lot of you out there are just like myself. We like to repair, modify, and upgrade our own guns. If you're looking for a way to take your hobby to the next level, then the Sonoran Desert Institute can help you. The online programs at SDI cover armorer's courses, gunsmithing, ballistics, woodworking and finishes, shooting sports management, and much more. Plus, the tools and materials are shipped directly to your door for hands-on practice. Guys and gals, it's never been a better time to get an education that you can actually use on the job. So, what are you waiting for? Click down below, and as well, if you click that link down below, sdi.edu/GNG, you can learn about financing assistance as well. Military folks, too. Click it down below, sdi.edu/GNG. All right, guys, also, if you want to stay up to date with this NRA stuff, subscribe to the channel down below. Let's get right into this, this agreement, this settlement that Mr. Powell came to with the state of New York yesterday. Here is the agreement, and I'm going to read it because I want you to see exactly what these people are doing to get off easy, to not go to prison. It says, "This stipulation of settlement is made and entered into as of the 5th day of January 2024, and by among defendant Joshua Powell and the people of the state of New York, together with Powell, the settling parties. Plaintiff is represented by the Office of New York State Attorney General Letitia James. Whereas the above captioned action was commenced against Powell, the National Rifle Association of America, Wayne LaPierre, Wilson Phillips, and John Fraser on August 6th of 2020 in the Supreme Court of the State of New York, the action. On May 2, 2022, plaintiff filed a verified second amended complaint in the action in which, inter alia, plaintiff asserts claims against Powell pursuant to the Not-for-Profit Corporation Law and the Estates, Powers, and Trust Law. Whereas Powell was employed by the NRA from 2016 through January 2020 and the complaint alleges that during his employment, Powell breached his fiduciary duties and failed to administer the charitable assets entrusted to his care by, inter alia, using his powers as an officer and senior executive of the NRA to convert charitable assets for his own benefit and for the benefit of his family members. Whereas Powell has appeared in the action, has served an answer to the complaint, and has asserted a number of defenses to plaintiff's claims and has testified under oath. Whereas the settling parties have engaged in good faith, arm's-length negotiations that led to this stipulation, which embodies all of the terms and conditions of the settlement among the settling parties. Whereas Powell has agreed to enter into the stipulation to avoid the risk of liability, as well as further expense, inconvenience, and litigation. Now, therefore, it is agreed by and among the settling parties, in consideration of the mutual covenants contained in the stipulation, the adequacy of which are hereby acknowledged, that all claims in the action against Powell be settled, compromised, and dismissed on the merits, and with prejudice, and without cost as to plaintiff or Powell, on the following terms and conditions, each of which is material to this stipulation, and which the parties respectfully request be so ordered by the court. Here's the stipulated legal conclusions. 1. Powell, in his capacity as an officer, director, and senior employee of the NRA, owed the NRA fiduciary duties of care, loyalty, and obedience. In addition, as a trustee pursuant to EPTL Section 814, because he administered property for charitable purposes in the state of New York, Powell had a duty to administer the charitable assets entrusted to his care properly. 2. Powell admits that he breached his fiduciary duties of care, loyalty, and obedience by inter alia using the NRA's charitable assets for his own benefit and the benefit of his family members. 3. Powell further admits that he failed to administer the charitable assets entrusted to his care properly. 4. Powell further admits that the conduct referred to in paragraphs 2 and 3 of this section violated Section 715 and 717 of the NPCL and Section 814 of the EPTL, and that as a result of such violations, he must pay restitution in the amount of $100,000 to remediate the harm to the NRA. Pursuant to EPTL 814 and NPCL 714, Powell hereby accepts a permanent bar from service as an officer, director, or trustee, or in any position where he has any fiduciary responsibilities for any not-for-profit or charitable organizations, incorporated, registered, operating, or soliciting contributions in New York, or for any other individual or entity that holds charitable assets or solicits charitable contributions in the state of New York, including but not limited to responsibility for financial and/or management oversight of any New York charitable entity. 6. Powell hereby agrees to pay restitution in the amount of $100,000, the settlement amount. The settlement amount shall be paid to the plaintiff, who shall hold the funds in escrow for the benefit of the NRA's charitable beneficiaries. Powell further agrees that the full payment of the settlement amount shall be made on the date that the stipulation is fully executed by the settling parties, provided, however, that plaintiff shall return the settlement amount to Powell in the event that his stipulation is not so ordered by the court. Plaintiff shall release the full amount of the settlement amount from escrow and transfer the funds to the NRA within 45 days of the entry of the final judgment in the above captioned action, unless an appeal has been filed, in which case the funds shall be released and paid to the NRA within 45 days after the exhaustion of all appeals or as otherwise ordered by the court. 7. Powell agrees that he will accept service of a subpoena for appearance at the trial. Trial includes any and all stages of the trial proceedings in this action, including the jury and bench trial stages, pretrial or post-trial proceedings, or retrials of this action, and will appear at the trial for as many days as are deemed necessary by the Attorney General, and will provide truthful testimony. Powell further agrees that A, he shall be responsible for all fees and expenses in connection with his testimony at trial. B, the subpoena referred to in this paragraph may be served by electronic means without tendering witness fees by email upon his personal email that has been used in this action, and C, that such service shall be sufficient service under CPLR 2303. Powell further agrees that he will not pursue any appeals relating to court orders in the action. Powell's appearance pursuant to subpoena is a material term of this settlement. 8. Dismissal of lawsuit with prejudice. In consideration of the covenants undertaken herein, plaintiff agrees that the claims against Powell in this action shall be discontinued with prejudice on the effective date, the date when this stipulation is so ordered by the court. 9. Resolution of all claims. This stipulation, upon being so ordered by the court, will resolve all outstanding claims by plaintiff against Powell relating to the subject matter of the action. Plaintiff hereby agrees that if this stipulation is so ordered by the court, and if Powell performs his obligations under this stipulation, it will seek no additional recovery or restitution of any kind from Powell in connection with the action, including but not limited to the contribution under NPCL Section 719 C and D for amounts recoverable from the remaining defendants in the actions subsequent to the execution of the stipulation. Nothing in the stipulation shall affect or limit the plaintiff's continuing claims against other defendants in the action. Additional terms and conditions. 10. Powell shall not take any action or make any statement denying, directly or indirectly, the propriety of this stipulation or expressing any view that the action is without a factual basis. 11. Plaintiff has agreed to the terms of this stipulation based on, among other things, statements made by Powell under oath in this action and representations to plaintiff. To the extent that any material statement made by a Powell during the course of the action is later found to be inaccurate or misleading, the stipulation is voidable by a plaintiff in its sole discretion. 12. No representation, inducement, promise, understanding, condition, or a warranty not set forth in this stipulation has been made to or relied upon by Powell in agreeing to this stipulation. Powell hereby acknowledges that he has had the opportunity to and has consulted with counsel in agreeing to this stipulation. 13. In the event that one or more provisions contained in the stipulation shall for any reason be held invalid, illegal, or unenforceable in any respect, in the sole discretion of plaintiff, such invalidity, illegality, or unenforceability shall not affect any other provisions of this stipulation. 14. If for any reason the stipulation is voided or breached, Powell agrees that any statute of limitations or other time-related defenses applicable to the subject of the stipulation and any claims arising from or related thereto are told from and after the date of the stipulation. In the event the stipulation is voided or breached, Powell expressly agrees and acknowledges that this stipulation shall in no way bar or otherwise preclude the plaintiff from commencing, conducting, or prosecuting any investigation, action, or proceeding, however denominated, related to this stipulation against Powell, or from using in any way statements, documents, or other materials produced or provided by Powell prior to or after the date of the stipulation. 15. The settling parties agree that this stipulation may be enforced by this court and submit to its jurisdiction for that purpose. In the event that a court of competent jurisdiction determines that Powell has breached the stipulation, Powell shall pay to plaintiff the cost, if any, of such determination and of enforcing this stipulation, including, without limitation, legal fees, expenses, and court costs. 16. Plaintiff finds this relief and the agreements contained in the stipulation appropriate and in the public interest. Accordingly, plaintiff accepts the stipulation and settlement of the claims asserted against Powell in this complaint. This stipulation shall be governed by the laws of the state of New York without regard to any conflict of laws principles. 17. Except as set forth above, the settling parties agree to bear their own fees, costs, and expenses of this matter. Nothing contained herein shall be construed to deprive any person of any private rights under law. Blah, 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 blah. And there you go. There's the signature of James Shaheen, who's the chief of the Charities Bureau for Letitia James, the Attorney General of New York, as well as the signature of Joshua Powell. So there you go. One of the people that New York was looking to sue has reached an agreement with the Attorney General to say, you know what, yep, I did these things. Let's just cut the losses here. I don't want to go through trial. I don't want to get any more than what I'm agreeing to now. Now, yesterday I was told that Wayne LaPierre has not reached an agreement with the Attorney General, and that wasn't part of his resignation. That doesn't mean he might reach an agreement today or tomorrow prior to the start of the trial, and if he does, I'll let you know. You want to stay in the know? Subscribe down below. I just think it's despicable what the folks who were entrusted with money to protect and defend the Second Amendment, I think it's despicable of what they actually did with that money. Enough said. Let me know what you think down below. I'll see you on the next one. Be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. See you on the next one. Take care.